Welcome to the D.C.Circuit Historical Society's program on judicial review of agency rulemaking. I'm Patricia Wald. I was a judge on the U.S. Court of Appeals for 20 years, and now I'm a loyal member of the Historical Society. The D.C. Circuit, as most of you have come to the program would know, has for 4 decades, and I believe that it's still true, it plays an unchallenged role as the flagship circuit in administrative law. And I think it is now embarked on what may be a new era of regulatory legislation, whose ultimate efficiency, as we all know, will be in its implementation by rules that must pass muster right here in the courthouse. Thus, as we've been warned many times, those who do not remember history are condemned to repeat it. And so a look back at the old debates and some current ones in the field should prove useful, if not indispensable, to the path forward. Now, for that endeavor today, we have a stellar cast of players whose credentials I can summarize only briefly. They cover all parts of the regulatory spectrum. So I'm going to identify them in terms of where they're sitting from the far right rather than in any other kind of substantive criteria. Michael Fitzpatrick is currently the Associate Administrator of OMB's Office of Information and Regulatory Affairs, known to its loyal fans as OIRA. OIRA is in charge of regulatory policy and agency rule review for the executive branch. Mike was formerly a partner at Aiken Gump, an assistant U.S. attorney, and a senior advisor to the Clinton administration's OIRA. He's a Stanford Law graduate and clerked for Judge William Norris of the Ninth Circuit. Now, next to him is Judge Brett Kavanaugh from the D.C. Circuit Court of Appeals. He's been a member since 2006. Judge Kavanaugh clerked for Justice Kennedy, and he worked in the Solicitor General's office and in the Office of Independent Counsel under Kenneth Starr. He was also a partner at Kirkland & Ellis and served more recently as associate counsel to President Bush. In his relatively brief tenure on the court, Judge Kavanaugh has written several important opinions in the administrative law era, and they're identified on your cram sheet, which was handed out to you. Howard Fox, sitting next to Judge Kavanaugh, is counsel for Earthjustice in Washington, representing here the very important NGO, non-governmental groups litigating, which is so heavily involved in agency rulemaking. Now, he has litigated and negotiated dozens and maybe hundreds of cases under the Clean Air Act, the Clean Water Act, NEPA, and other laws. And finally, Paul Verkuil has just been confirmed last week, an achievement in itself, as the chair of the newly resurrected Administrative Conference of the U.S., or ACUS. He's been president of William and Mary College and dean of Tulane, Cardozo, and Miami law schools, as well as a Supreme Court appointed master. But perhaps even more relevant for our purposes, he's written widely on the subject of agency review of the courts. 60 articles and a book, in fact. 2 of his articles are on your cram sheet, handed out at the door, and on which you will be tested at the close of the proceedings. And finally, we have to guide us on our sojourn through this fascinating but sometimes labyrinthian subject, Jeffrey Lubbers, who's professor of practice in administrative law at American University's Washington College of Law. Jeff is also the author of the ABA's Annual Guide to Federal Agency Rulemaking and a former research director of the old ACUS. He has taught law in several law schools in the United States and in Australia, Japan, Canada, China, and he's a recipient of the Mary Lawton Award for Outstanding Government Service. So take it away, Jeff.
Well, thank you very much, Judge Wald. It's a great honor for me to be introduced by you. I'm sure everybody in this audience knows what a great judge and great administrative scholar you are. And I want to thank you and Steve Pollack for inviting me to be part of this program. It's a thrill for me to even be in this courtroom, much less be associated with this distinguished panel and with this distinguished audience today. Now, I'm old enough to remember these great judges of the D.C. Circuit from the 1970s, 60s and 70s even. And these were the ones who figured so predominantly in the debate over judicial review of rules. In fact, when I first joined the Administrative Conference of the United States as a young lawyer back in 1975, by the way, I am thrilled that it's being resurrected, my first assignment was to work on a research project concerning whether and when agencies should use procedures in addition to the notice and comment procedures of Section 553 of the APA. And that project was going through the Judicial Review Committee of ACUS, and one of the key members of that committee was Judge Leventhal, who was serving as the liaison member from the Judicial Conference. And I well remember one of my first meetings was in his chambers to talk about this project with the consultant who ACUS had hired for that project, who was a professor from Colorado named Stephen Williams. So it's kind of amazing that that some of this is coming full circle today. Now, to set the scene for today's debates about judicial review, I'd like to go back to the debates of the 1970s for a few moments. The 1970s have been called the consumer decade, and it was also the decade when rulemaking came to the fore. Prior to that time, agencies tended to make their policy through case-by-case adjudication. But reformers extolled the virtues of rulemaking, and Congress in the early 1970s passed a series of laws such as the OSHA Act, Consumer Product Safety Act, Highway Safety Act, Federal Trade Commission amendments, and numerous environmental statutes that either required or at least relied heavily on agency rulemaking. According to Professor Rule Schiller, whose article I really commend to you, it's listed on the readings, in 1960, the Federal Register averaged 41 notices of proposed rulemakings a month. By 1967, it was up to 86 per month. But by 1974, it was over 190 a month. So you can see that there was a rulemaking explosion. At the same time, the judiciary, following the lead of the Warren Court, was becoming more activist, especially in the area of civil rights, equal protection, and due process, but also in the area of judicial review, with the 1966 Abbott Laboratories decision, which paved the way for pre-enforcement judicial review of agency rules, and the 1971 Overton Park decision, which suggested that the APA's arbitrary and capricious review standard required the court to, quote, consider whether the decision was based on a consideration of the relevant factors and whether there had been a clear error of judgment, and required a searching and careful inquiry into the facts. As the locus of most of the judicial review of agency rules, the D.C. Circuit had to figure out how to review these rules. And this is where some great minds did not think alike. And even though they were politically in agreement for the most part, the judges I'm going to be talking about were all New Deal Democrats, so it wasn't really a political disagreement. On the one side, we had Chief Judge Bazelon, who felt that judges were experts on procedure, not on the substance of regulation, and he wanted the courts to ensure that the agencies used the procedures and built the sort of record that was necessary to make the best decision. On the other side, we had Judge Leventhal and Judge Skelly Wright, who felt that mandating additional procedures would force agencies to err on the side of over-proceduralization and would ultimately slow down the rulemaking process, what we would call ossification today. They believed that judges should examine and try to understand the technical matters at issue in order to determine whether the agency had exercised reasoned discretion. Even before Overton Park, Judge Leventhal coined the term hard look. He wrote in 1970 that the judiciary's supervisory function calls on the court to intervene if the court becomes aware that the agency has not really taken a hard look at the salient problems and has not genuinely engaged in reasoned decision-making. That was an adjudication case, but nevertheless it caught on in rulemaking. And in two 1973 cases involving EPA rulemaking, Judge Leventhal put his views into practice. In International Harvester Company versus Ruckelshaus, Judge Leventhal, along with Judge Tam, upheld a technical EPA rule concerning auto emission requirements. And also in the same year, in Portland Cement Association versus Ruckelshaus, he overturned an EPA rule that limited stationary source emissions by cement plants. In each decision, he wrote a lengthy analysis of the scientific and engineering aspects of the rule. And he wrote, quote, "While we remain diffident in approaching problems of this technical complexity, the necessity to review agency decisions, if it is to be more than a meaningless exercise, requires enough steeping in technical matters to determine whether the agency has exercised a reasoned discretion." Judge Bazelon concurred in the International Harvester case, but disagreed with the majority's approach to the review. He said, and I quote, "Socrates said that wisdom is the recognition of how much one does not know. I may be wise if that is wisdom, because I recognize that I do not know enough about dynamometer extrapolations, deterioration factor adjustments, and the like to decide whether or not the government's approach to these matters was statistically valid." Shortly after this, Judge Leventhal, Judge Wright, and Judge Bazelon took to the law reviews to defend their positions. Then came the 1976 5-4 en banc decision in the Ethel Corporation case involving a challenge to the EPA rule that required dramatic reduction of lead in gasoline. A three-judge plurality, Judge Leventhal along with Judges Wright and Robinson, upheld the EPA after a long and detailed analysis of the studies upon which the agency based the regulation. Chief Judge Bazelon with Judge McGowan wrote a brief concurrence, that's making up the five, which attacked both the plurality's opinion and the dissent, which had refuted Judge Wright's hard-look analysis. And Judge Bazelon felt that this case showed just how unqualified judges were to evaluate the technical aspects of the rulemaking. But he felt that because EPA had provided interested parties with sufficient opportunities to present evidence and rebut the agency's evidence, the regulation should be upheld. We all know what happened next, Vermont Yankee. This case concerned a rulemaking by the Nuclear Regulatory Commission that was designed to help the agencies avoid having to have an adjudicatory hearing in every licensing on the environmental impact of nuclear power plants. The environmental groups challenged the rulemaking and the D.C. Circuit overturned it. Chief Judge Bazelon's opinion for the court held that the NRC needed to provide opponents of the rule with some opportunity to challenge the testimony of the agency's experts, and so the rule was remanded. But the Supreme Court unanimously reversed. In his opinion, Chief Justice Rehnquist cited Judge Wright, Skelly Wright, and said that the D.C. Circuit's Monday morning quarterbacking of the rulemaking process would cause agencies to err on the side of formal procedures and that all the inherent advantages of informal rulemaking would be totally lost. The upshot, of course, of this decision is that afterwards, courts were not supposed to require agencies to use procedures in rulemaking that beyond those required by the APA or other relevant statutes. Then, of course, we had the Chevron decision of 1984 concerning review of legal determinations of by the agencies, in which the court decreed that reasonable agency interpretations should receive deference. But hard-look review of agency fact-finding and policy choice under the arbitrary and capricious test of the APA survives, as we've seen from the 1983 State Farm decision and the recent Fox television case. Now we finally flash forward to today, and we have the interesting opinion by Judge Kavanaugh, which raises concerns about hard look. And there's an extract from the opinion in your readings. So this is where we'll start. I want to make sure that you all have a chance to ask some questions or make some comments in the last half hour. But let me throw out the first question to the panel, and then I'll go back and sit up in the dais. The question for you is, and any of you or all of you can opine on this, is would all of you agree with the premise that the streamlined APA rulemaking process has since become encumbered with extra requirements these days, unduly ossified, to use the academic word? And I'll take a volunteer for that question.
Well, I think maybe I'll volunteer. Get started. And just say that is the belief, at least in the academic community, that so-called ossification. Tom Garrity and others have written extensively, Dick Pierce, at GW is here because of what happened as a result of Vermont Yankee, which is that agencies have been forced in order to, at least before Vermont Yankee, were forced to bolster their rulemaking to satisfy procedural requirements that they couldn't anticipate unless they took a special care at the beginning. And then State Farm more or less preserved it by turning the hard look doctrine into a variation of that theme. But I think Michael probably has the more current word if you want to talk.
I will start by saying I hope I don't have to cite this precedent later, but that obviously the views expressed here are those of myself and not of the administration. I think that we spend...
Oh, I have to learn how to say that.
Yeah. We spend less time than you might think unpacking the current state of the hard look doctrine in reviewing rules. This may come as a surprise, it may not. We do care about some fundamental things in the course of reviewing regulations, and I don't know how familiar all of you are with the OIRA process. I don't know how familiar all of you want to be with the OIRA process, but we essentially review, on behalf of the President, 500 to 700 of the most significant rulemakings that come out of the non-independent agencies every year. And we coordinate, importantly, an interagency review process. And we work with the issuing agency to respond to comments that arise. There is a legal component of that. Jeff, is it okay if I just take a minute to talk about this? Because I think this is principally what I can offer to this august body today.
I'll call on you later anyway.
Yeah, I know you will. But there are certain legal issues that absolutely arise during the course of our review and that we try to tackle. They don't quite get into this level of specificity, but they center around some key concepts. The first is we grapple with issues as to whether or not the rule is complying with the statute. That would seem to be the most important issue that one grapples with. How is the agency acting within its delegated authority properly? And every president has an interest in ensuring that that's the case. That implicates certain questions that revolve around Chevron. How ambiguous or not is that delegated authority, that statutory mandate? How much discretion does the agency have? And we are advised by the DOJ, by OMB General Counsel, by White House Counsel, and by the agency General Counsel in that process on those issues. Another is whether or not, after comment, any changes to the final rule are logical outgrowth of the proposed rule, and how the comment period was set up. It's a very important issue, and it's one that gets assessed in certain situations when there are changes. Another is good cause. Agencies are often desirous of using expedited procedures to get their rules in place. Oftentimes those are entirely justified. Sometimes there's a question about that. And so we do look into the justification under the good cause doctrine, and we will do sometimes some legal analysis on that to assess litigation risk. And then there are the normal issues of have they considered alternatives adequately? Is there an adequate support in the record? Have they responded to comments? And I would just say quickly the last issue that we grapple with is this ossification issue, actually. It's all of these other requirements that have been sort of layered on top of agencies over the decades, each of which may have been very well intentioned and in fact meritorious in and of itself, but for which I think there's a legitimate question in the aggregate whether they are unduly burdening agencies. And those are things like the Reg Flex Act requirements, the unfunded mandate requirements, SBREFRA, which I helped actually implement in the mid-90s. All of these things do add burdens and require resources at the agencies. And that's something that we actually have to make sure that the agency is complying with when the rule goes out.
I think it's fair to say that all three branches have added on additional requirements to the original APA rulemaking process. But let's think about that. Well, Howard, do you want to add something?
Go ahead.
As I recall, I know it's very important to listen to the way the question's worded. Your question was, has the rulemaking process become encumbered? And at the end you said, these days, meaning recently. And I think I would say that the basic structure of the way, at least my experience is mainly with the D.C. Circuit in judicial review. The way the D.C. Circuit has approached these issues and review of rules and even other actions over the last quarter century or so is the guidelines for how that happens have pretty much been in place for the Chevron case, which was 1984, the motor vehicle case, which was 1983, and Vermont Yankee, which was even earlier. By that time, essentially, those are really the guiding lights for, at least absent a constitutional issue, for how the court approaches these issues. And I think the real issue comes down to how do individual judges in individual cases apply those doctrines. And the thing that has started to happen a little more recently, is bringing in, at least in my area, the environment, which the Constitution didn't really figure big in the environmental law field for a while. More recently, there has started to be a little bit of use of the Constitution to create a sort of clear statement approach. I'm thinking of the solid waste case in the Supreme Court under the Clean Water Act, where the Supreme Court brought in a sort of constitutional issue and said, the agency wants Chevron deference, but we're really not going to give the Chevron deference here because we want to avoid this constitutional issue we perceive. That's a more recent development, I think.
Okay. Let me pose a question to Judge Kavanaugh then. You have the extract from his radio relay case, and I read that as making two basic points, Judge. One is that in the you were partially dissenting in this case, partly because you felt that the Vermont Yankee decision was being circumvented, in a sense, and secondly, you thought that the arbitrary and capricious test had, as you say, grown into a far more demanding test, even more than the State Farm recitation of the test, so that now the arbitrary and capricious test itself appears arbitrary and capricious. You want to expand on that a little bit?
Let me begin by thanking the Historical Society and Steve Pollack for putting on this program. It's a great contribution to the court and to the bar of this court, and so I'm honored to participate and to help answer or avoid questions. I also want to thank Judge Wald for being here. Of course, Judge Wald has written extensively as both a judge and in the law reviews on this topic, and made extraordinary contributions. And so it's daunting to be here talking about some of the issues which she spent so many years explicating for all of us. Let me give you an overview and tell you how I come at it. When we're handling administrative law cases, there are two basic, to oversimplify greatly, two basic kinds of cases we'll get. One, of course, is whether the agency, as Michael pointed out, is complying with the statute. If the statute specifically sets forth a standard, is that a clear standard? Is that an ambiguous standard? This is known as the Chevron doctrine. And over time, as Judge Wald has pointed out in some of her articles, the Supreme Court has become much more textualist. And so, too, I think, following the Supreme Court's lead, as we're supposed to, the lower courts have as well. And what that has meant is that courts have become much greater sticklers, I would say, now than 20, 25 years ago in making sure that agencies comply with the precise terms of a statute. I think sometimes in agencies, and I worked in the executive branch for many years, sometimes in agencies there's a sense of Chevron deference or just deference. Oh, the courts will give us deference. Well, not really. You need to pay attention, of course, in agencies, as Michael pointed out, to the precise words of the statutory scheme. And so that's one big category of the cases that we see in administrative law. And I think if you sat for a week listening to D.C.Circuit cases, and I don't advise anyone to necessarily do that, but if you sat for a week and just listened to a lot of cases, you would hear judges of all supposed philosophical and ideological stripes saying, but what do the words of the statute say? What does the text say? We're really focused on that, as is the Supreme Court. Okay, second big category of cases is what is known as arbitrary and capricious review under the Administrative Procedure Act. And this is the overview that we have heard so far. And my concern over that test is really not new to me, but it is that the amorphous nature of the test lends itself to unpredictable, expansive judicial activity that sometimes can hamper unduly the actions of the executive branch. And I come at that from a number of different perspectives. And again, these are just in the nature of concerns. Obviously, in different cases, it'll come out differently. But first of all, I think the arbitrary and capricious language was put in the 1940s at a time, remember, we had just come through as a country the difficult time with judicial activism and then judicial restraint, and the Roosevelt justices were on the court, and there was really a culture of judicial restraint, not using the courts to unduly second-guess legislation, and that too, I think, carried over to the original understanding of the Administrative Procedure Act. It wasn't necessarily supposed to be this grand tool where courts were essentially partners with the executive branch agencies in figuring out the best way to go about it. Secondly, my concern about it sometimes is how unpredictable it is. It is no fun being in the executive branch trying to speculate what any three judges will do on an arbitrary and capricious case. I've been there and tried to do that. It is very tough. Judges, I think, do a good job at figuring out what the statutes mean, what the law means, sometimes figuring out different provisions of a statute, how they fit together. That doesn't mean there's never disagreement. But when you get into the arbitrary and capricious review, it can be much more unpredictable, and that's a problem. It slows down, therefore, rulemaking. It slows it down on the front end where you're trying to guess, what might a court do in this instance? So that's a problem. And then if it gets remanded for further explanation, that slows down the whole process again. When working in the executive branch, one of the things, if you wanted to slow something down, was to process it to death. Well, courts can essentially do the same thing, and inappropriately, in my view, at some times. There's another problem, which is each of us goes through a confirmation process where we're analyzed, I guess is one word to put it, and for what perspective we might bring to the bench. And each of us testifies to the Senate Judiciary Committee that we're going to follow the law. Whatever personal policy preferences a judge might have are not going to find their way into judicial decision making. When we're interpreting statutes, when we're interpreting precedent, I think we do a fine job of that. When you invite judges through overly aggressive arbitrary and capricious review to second-guess agency decision-making, it becomes much more tempting for judges to say that something, this is unreasonable, this regulation, I disagree with this policy, just send it back for more reasoned decision-making. I'm not saying that happens, but certainly if you're asking two judges who come at policy issues from a different perspective, is this unreasonable? Is this sufficiently explained? That's going to invite a lot of non-legal considerations into the mix. And it creates, therefore, the impression of politicized judicial decision-making if arbitrary and capricious grows too broadly, which is also a concern of mine. Certainly Professor Sunstein has written articles which Judge Edwards on our court has responded to, I think, persuasively, but nonetheless there's a perception out there sometimes that decision-making becomes the policy preferences of the judges. So all of that influences my concern that I articulated in that opinion. And that's not to say that I think arbitrary and capricious review should be a rubber stamp. I think I've made that clear, and I think our court makes that clear repeatedly. But when challengers to agency regulation come in and say, judges, you should strike this down as unreasonable, as arbitrary and capricious, it's hard for us to know what precise factors we're supposed to look at. So sorry for the overly lengthy overview.
It's certainly a difficult phrase to explain to the students. I mean, my students as well. But just to be the devil's advocate for a second, when the procedural review has been pulled back by Vermont Yankee, and when Chevron has made judicial review of statutory interpretations more deferential, it seems like arbitrary and capricious review is the only tool that courts have to prevent either overly activist or overly captured agencies. So,
well, I guess I would go back to something Judge Wald's written many times, which is, as a matter of basic separation of powers, courts feel uncomfortable getting in the middle of the conversation between Congress and the executive branch over the proper ways to regulate a particular industry. And so if the president and the president's appointees are properly supervising the executive branch, and if Congress, which it does, oversees the agencies, formulating whether a particular, or deciding whether a particular rule is out of bounds, if it doesn't violate a statute, seems to be primarily an issue for the political branches to sort out. That's not to say there can't be problems, and of course, courts, if given a more expansive role by Congress, would exercise it. It is to say that the primary people who should be assessing the wisdom of regulation, the policy wisdom of regulation in our system of separation of powers are the executive and legislative branches.
And we have OMB review now, so maybe that,
Right.
Mike?
Well, I mean, there's no doubt that the mere fact that it goes through OMB review should per se immunize it from any challenge. Can't possibly be arbitrary or capricious.
So we don't need any judicial review now, huh?
No, but I do, I think, agree with Judge Kavanaugh on the basic premise that it's essentially, I think, primarily a relationship between Congress and the executive. I would add, without taking a position on it, an interesting note here, and that is that in the mid-'90s, there was an act that was signed into law called the Congressional Review Act, and the intent of that act was, and Congress passed this to provide itself with motivation and a mechanism to review the delegated authority to the agencies on a transactional basis. And I would just note, without drawing an opinion, that it has only been used once in its entire history to overturn a regulation, and that was the ergonomics rule that came out of the Labor Department. And you just went through a period that would have seemed propitious for its use when you had the change in administrations from Republican to Democrat and an overwhelming majority in the Congress of the same party as the president, and a large group of regulations that were issued at the very end of the prior administration. So, and yet 0 regulations were overturned, and in fact, I think 0 resolutions of disapproval were introduced. So it does raise an interesting question about that. If the Congress and the executive are in essence, if that's the relationship and they're the ones who should be policing themselves, and you have the Congressional Review Act there, which is essentially unused, I think it does raise a question as to whether that relationship is going to be robust.
One of the things you said was about agency capture, and if we're talking about the traditional executive agencies here, the president ultimately is responsible for what the agencies do and for appointing people who will fill in the statutory gaps and make the policy choices on behalf of the president. I think an interesting separate issue which we may discuss is independent agencies which do operate without as much centralized supervision from the president. Certainly when I worked in the White House, the idea of influencing independent agencies was considered a very serious matter. I know there's been a lot of law review commentary, the president still controls independent agencies. Most of those people have not worked in a White House who write that. Because really,
I agree with that.
That really does not happen, actually. And there's a great fear, whether it's legal, political, whatever, there is a great fear for anyone who works in a White House about any contact with an independent agency. But I just flag that as a separate issue to keep track of.
Okay. Let me just ask Howard. I see Paul's getting ready to say something. I want to just ask Howard about, since you spend most of your time either defending the EPA when you agree with it or challenging the EPA in court, how would you feel about a sort of Vermont Yankee 2 type of decision that applied to the arbitrary and capricious test?
I'm not sure we need one, really. I think that the way I see it, you correctly said, you correctly made the very important point, which is that whatever side in the NGO world or the non-governmental world you have interests that it sometimes want the agency to win and sometimes are challenging the agency. And that's, I work for an environmental organization. That's true from our side of the fence. But also, if you look at industry, they have the same perspective. There's times when they intervene as respondents or submit amici as on the side of the agency, and times they're challenging the agency action. So I think on both sides there's some inherent interest in having a referee available, but not have the referee be too intrusive. I really look at this as sort of from a separation of powers point of view, that if there's kind of like a balance to walk in the middle, and if the judiciary didn't really invite itself into reviewing rules. I mean, part of what Congress wrote statutes that gave the authority to the judiciary, the Administrative Procedure Act being one of them, and there are others like Clean Air Act has its own judicial review provisions, for example. They're actually more specific than the Administrative Procedure Act. Congress has written statutes which you could say, well, that's the end of the story. They send the agency off to implement the statutes. But also, it's also written statutes that said, we want the judiciary to be involved in policing how the agencies implement those statutes. So when the judiciary does that, it's really not going outside of its boundaries. Now, this discussion is very abstract right now, so it obviously depends how they approach that in a given case. And as I understand the D.C. Circuit jurisprudence, having followed it for decades, is that the highest degree of deference is given where I think it's appropriate, where the statute gives the most room, statute speaks least, maybe the operative word is may rather than shall, the subject matter is technical, economics, or an overt policy focus to the decision. The more it involves prediction about what's going to happen in the future, if you have a complex, non-statutory governed prediction about the future, that's where deference is going to be at the maximum. On the other hand, the more specific the statutory scheme is, the agency that wants to get around it may actually try to use some kind of factual argument or gobbledygook rationale that then it's really up to the courts and the arbitrary and capricious standard to unravel and not let the agency get away with that. And institutionally, I'm all for the congressional oversight committees and so forth. I think that's very important. And I'm not sure that they're institutionally equipped to get into the weeds of every single agency action. And we're talking here about rules, but remember that the APA applies this arbitrary and capricious standard to pretty much every kind of action. For example, a lot of the cases I've worked on involve some sort of licensing or permitting. For example, the Corps of Engineers issues permits under Section 404 of the Clean Water Act for the discharge of dredged and fill material. And when they issue a permit, which environmental groups or others think go too far, they challenge it. And when a permit is denied, the industry group or the developer, whoever, will challenge the denial. And that is all reviewed under the same standard. So I'm not sure if there's a doctrinal basis to say we're going to back off on the arbitrary capricious standard as it applies to rules, but continue to be tougher when we're doing review of permits and other actions. So.
Well, let me just bring us back to the history because it is interesting. Now we're really on top of it all. And since this is about the Bazelon and the Leventhal debates, I just would like to make a personal observation of my relationship with Judge Leventhal in particular, because my first task for the administrative conference as a consultant when I was teaching at Chapel Hill, North Carolina, at UNC, was to do a study of judicial review of informal rulemaking, where we were starting in the early 70s. And as a result, I had to work for Judge Leventhal, and because he was, as you had suggested, was very active in the administrative conference, which I'm very proud of. And at one point I said, Judge, we had these EPA rules. And this was the beginning of EPA, so that's the other thing. There's been an evolution here. At the beginning, these rules were coming out, and the agency itself wasn't as structured. And I said, Judge, this stuff is really complex. He said, Paul, he says, complexity, it has a bright future. And that's where we went. We did this rule, and an interesting thing about, at the time, judicial review of informal rules wasn't done very significantly or seriously at all, because this case Jeff just mentioned in passing, the Abbott Labs case, was only recently decided. Abbott Labs is what made it possible to have pre-enforcement review. In the old days, right? Before that, you waited until the agency not only enacted or promulgated the rule, but then they had to enforce it, and that might be several years later. And then when the enforcement action came up, if you're attacking or defending the agency, you were focused on the as-applied challenge, really. You know, did this agency have a right to go after this particular company for that? And you forgot, into the background were the processes of rulemaking. And so when Abbott Labs came along, and you could now go right after a rule, as soon as the rule is promulgated, judicial review is taking place, all of a sudden we were focusing on the processes, the procedures. And that's how we got into this, to this mix and this focus, which led ultimately to Vermont Yankee. And then the only question became, well, if Vermont Yankee really, and I do think quite sensibly said, look, we can't keep adding procedures to the APA for informal rulemaking. It was always meant to be very limited review. That's what the statute was intended. It was, after all, in the old days, specific states box, Brandeis's opinion. Only you treated rules like you did statutes, and you would defer to the agency like you defer to Congress. And if necessary, you'd make up the facts in order to support the rule. All those things changed, obviously, but that's where we came from. And now we came through Vermont Yankee, and I think we got, we were cautious. And then State Farm, and State Farm is such an interesting case. It's really two cases. It's a 9-0 case which says the failure of the agency to consider airbag-only alternative was a failure of its activity. It really was part of the arbitrary and capricious problem, and that was 9-0. They failed to consider an alternative. That's pretty clear. But then when you got to the real arbitrary and capricious question about the policy issue, was this a good idea to have this change in process come about at the advent of the Reagan administration? Then the court was 5-4. That's the second opinion in State Farm. And that's the famous moment when Justice Rehnquist said, this is a political question. He dissented in one of the four. This is a political question, really. It's more policy, and therefore arbitrary and capricious ought not to be imposed in too strenuous a fashion. We ought to leave it to the agencies and to the executive branch. And that, of course, that language about it being we are not one of the political branches, we the courts, was picked up really by Justice Stevens in the Chevron case, which confirmed the notion that there should be more deference. But it hasn't quite built itself back into the arbitrary and capricious review itself per se. I think that's where we're still...
So let's talk about the so-called hard look test. I once checked and found that the Supreme Court had never used the term hard look in the context of rulemaking review. And also in the same term that the Supreme Court decided State Farm, it decided the return of the Vermont Yankee case, the Baltimore Gas and Electric case, which the D.C. Circuit had, after a remand, reversed the NRC again, this time on the arbitrary and capricious test. And the Supreme Court once again reversed the D.C. Circuit and said that reviewing courts must give great deference to an agency's prediction in the area of its expertise at the frontiers of science. This, to me, seems like a soft look. And yet, the hard look idea has survived. We've had a little bit of pullback in the recent Fox television case, the fleeting expletive FCC case, where Justice Scalia said that the hard look test of State Farm did not require an extra amount of explanation by the FCC when it's changed its position. But what is the current state of the hard look test? Is there really a hard look test? And if that's not the appropriate test, how should we reframe the test? Should it just be a reasonableness test? Does that help? What is the best way to talk about it? Let me also drop a footnote here. This might be the appropriate place. Unless I'm wrong, Mike's dad argued the State Farm case and won the case. Correct?
We'd like to emphasize the 9-0 part of it.
9-0. So it's actually the Fitzpatrick family that's responsible for this.
I think the FCC versus Fox decision of last year is very important, actually. Justice Scalia's majority opinion in that case makes clear that no special explanation is required when an agency changes course. Big point, something that had been debated a lot in the lower courts before. And secondly, I think the court, if you read the opinion as a whole, does suggest a, as you call it, soft look rather than a hard look. And I think State Farm itself doesn't suggest necessarily a hard look. Maybe it was not Vermont Yankee 2, but it was Vermont Yankee 1.5. There's different language in different parts of State Farm that actually different judges pull out in different cases, as you've cataloged over the years, depending on how we're turning out. But I think the question really in most agency cases under arbitrary and capricious review is, was the agency decision reasonable and reasonably explained? It really boils down, in my judgment, and that's a formulation that the D.C.Circuit has used several times to describe what it means. Now, I should add one thing, which is in saying, expressing my concerns about an overly expansive arbitrary and capricious review, like anything in law or life, there's a balance. And needless to say, and to reiterate, arbitrary and capricious review is an essential part of judicial decision making. I think it serves a useful function in ensuring that agencies don't jump the rails completely. And so striking the right balance in terms of the appropriate judicial role is what we strive to do in our case law.
Mike?
Can I just make one point on that as well? And that is that I think that without getting into monikers like hard look, soft look, I think there is an awareness on the part of the agencies in the executive branch that people sue in this country and that courts take a close look at agency actions. You don't sit up here and just sort of read the New York Times on your laptop while the oral arguments are going on. It's a close, careful look at what agencies are doing, because what they're doing is absolutely impacting, both good and bad, the American people. When we are going through this very intensive review process, one of the key questions we keep asking ourselves, and it's not, again, tied to particular cases in this doctrine, but it is there a very strong analytical underpinning for what the agency is doing? Is their regulatory impact analysis tight? Is it strong? Have they considered alternatives? Have they qualified and quantified all of the costs and benefits? And those are all important features, I think, of a healthy rule going forward that is going to, and I think, have a greater chance of surviving a judicial challenge. And so it's our goal in the Obama administration to try to bat as close to 1,000 as we can in terms of the rules going forward. Have they been vetted by other experts at other agencies and folks in the Executive Office of the President for analytical rigor and support? Have the comments been considered? Has the agency looked at alternatives? So those are, I think, a robust process like that should increase, I think, the and a rule's ability to survive a careful review in the court.
Well, let me ask whether these formulas for judicial review really matter. In preparing for this, I came upon an article by, I guess this is a shout out to my friend David Zering, who teaches at Penn, and he has an article coming out in the University of Virginia Law Review, in which he demonstrates that agencies tend to be affirmed by the courts about 2/3 of the time, no matter what formula of judicial review is being used. And he says that he identifies a number of different formula. Under factual review, you have arbitrary and capricious, and you have substantial evidence for those formal adjudications. For review of legal questions, you've got Chevron and you've got Meade. Then you have de novo review for purely legal questions. And he says that all of these formula have been kind of coalescing and can be reduced to one word: reasonableness versus unreasonableness. And he advocates substituting a reasonableness test for all of these different formula that we try to impart to our students and come out of the APA. And so I'm just wondering whether this attempt to parse these different formulas is really worth the effort.
I can give you another example, which courts will know. The two largest numbers of cases, groups of cases that come to the federal courts are FOIA cases and the Social Security disability cases. In FOIA, it's a de novo standard of review, so that the district judge actually takes a look without any deference. And in the Social Security cases, it's a substantial evidence, which is a very deferential standard of review, not quite as deferential, allegedly, as arbitrary and capricious, but deferential. So when I counted up all these cases, you might think, in other words, that the reversal rate in the courts would be higher if it's a de novo review standard, because the court is taking a fresh look with no obligation to deference, than it would be in a substantial evidence. But of course that doesn't work out. In the affirmance rate in FOIA cases, for other reasons, is 90%, and the affirmance rate and remand rate in Social Security disability is about 50%. So here you get a real disparity between reversal rates in an area, and these are numerous cases, so you actually get a really good sample size. It seems counterintuitive on the face of it to have a non-deferential standard providing such high affirmance and a deferential standing providing such high reversal, which leads me to say, Jeff, that maybe that's right, that what do these words ultimately tell us? Can we rely on them in a meaningful sense, or isn't there something else going on in the FOIA situation or in the disability situation that really explains the reversal rates, and we have to look beyond the titles of the review staff?
We all know that step 2 of Chevron is a reasonableness test, and it's hard to really distinguish that analysis from the arbitrary and capricious test. And some courts have basically said that they're the same, and some have tried to keep a different analytical approach to those two questions, but it's pretty hard to distinguish them. Substantial evidence is a reasonableness test. So, what is really the difference here? Ernie Gellhorn once and Glenn Robinson once famously said that the rules governing judicial review have no more substance at their core than a seedless grape. And
when you go back to the first two categories I talked about, the Chevron statutory interpretation category and the arbitrary and capricious category, in the Chevron category, statutory interpretation, don't forget step 1. So reasonableness, I think this is the mistake that I articulated earlier that's sometimes made by agencies, that, as long as it's reasonable, as long as we're within the ballpark of what the statutory language means, we'll be okay. Not true in our court or in the Supreme Court with modern statutory interpretation and textualism. On the other category, arbitrary and capricious, I agree with you. I think it does boil down to reasonableness along with a reasonable explanation. Now, of course, that was to shift to review of legislation. That, of course, was the test the Lochner judges were applying as well. So that's my point about judges need to be cautious. The word narrow from the State Farm decision needs to be remembered about what our role is. Every case I think we sit on in a separation of powers case, an administrative law case, I like to think, what is my role here? What exactly? I'm not here to do your job or to do the job of EPA. On the other hand, if Congress has written a statute that has words and an agency is flouting it, it is my role to say that's not going to pass muster. So I really focus on that.
And on the Constitution, as you did in your recent case.
Sure, if there's a constitutional issue, obviously. One other point I wanted to mention, which is there's sometimes a feeling, I think, that if there's been White House influence or presidential influence or policy influence coming from OMB on an agency decision, that somehow makes it improper. And again, Judge Wald's Sierra Club opinion is the most prominent explanation of why that's not just proper, but should be expected in a government in which the president exercises the executive power. That's something that I think is important to keep in mind as you think about arbitrary and capricious review, because I think sometimes people think, well, there's one scientific answer to this question. Oftentimes there are a range of reasonable answers. Some might be more supported by the evidence than others, but there's a range of reasonable explanations. And an administration chooses one because that's their policy, and that's what the president ran on when he or she was in Iowa and New Hampshire and ran on more aggressive or less aggressive environmental regulation or labor regulation. We do a disservice to the political process, again, if we're overly aggressive in second-guessing that role or interfering with the president's role.
Howard, there have been a couple of decisions recently that have made it a little more difficult, maybe a lot more difficult for environmental groups to actually gain access to the courts because of the standing ripeness doctrines, finality doctrines as applied to non-regulated parties. And how does that fit into this analysis at this point? Would pulling back from arbitrary and capricious review be sort of another difficulty for public interest in environmental groups?
Well, it really depends on it really depends on which rule you're talking about. If you're talking about what the clients and environmental groups want, that's one thing. But in terms of what you're specifically talking about, the justiciability case law, of the things you list, some of them really affect both sides of the fence. They would affect an industry plaintiff, a finality issue, for example. Even ripeness, which is often cited as something that affects us. Also, there are many cases dismissing industry claims for lack of ripeness as well. The one that we probably spend the most time concerned about is the standing one. And it's a matter of concern for several reasons. One of them is that it's been interpreted in a sort of asymmetrical way, as you point out, where there's this concept of the target of the agency action, and if you're not the target of the agency action, then it's more difficult to show standing under the Lujan v. Defenders decision. In practice, there's a wide range of cases where we have been able to establish standing. There's the very important Supreme Court case from the 1990s, the Friends of the Earth v. Laidlaw, that kind of moved the bar back in favor of standing. But the other feature of standing that's problematic is, of course, it's drawn from Article 3 of the Constitution. So you have, this is another one of these separation of powers issues, because you have, on the one hand, Congress enacting statutes that both set forth the substantive rules, like the Clean Air Act, Clean Water Act, here's the type of standards we want, and they're saying we want to have the various interested parties and affected parties be able to police this in court. And that legislative judgment about wanting to have plaintiffs be able to sue then runs into this constitutional doctrine, which it's hard for Congress to fix because it is based on the Constitution. And you wind up with a sort of leaning tower of Pisa if the agency starts out in the middle as being pushed by industry advocacy within the executive branch. We can theoretically push back in the executive branch, but then in court, if you can only have one side pushing in court, over time, that's going to lead to a tilt in one direction away from just a down-the-middle implementation of Congress's mandates.
Okay, well, that's a topic maybe for next year's D.C. Circuit Historical Society meeting. I see we have about 28 minutes left. Does anybody want to say anything before we get some comments and questions from the audience?
I'll add one thing, which is you've said a couple times whether we should pull back on arbitrary and capricious review. It strikes me that that's loading the dice a little in terms of where we are, because it seems to me that the courts right now are fairly deferential in arbitrary and capricious review. So there are occasional hiccups and occasional disagreements among judges in what they see in a particular case, but I think the baseline right now is a fairly deferential arbitrary and capricious review in rulemakings. Howard makes an excellent point about adjudications being somewhat different. I think when a judge sees one person who's gotten a raw deal in an adjudication, that is a different kind of case than a forward-looking rule that's going to be set rules governing future conduct. And so I think in practice you might see a slightly more aggressive form of arbitrary and capricious review in a adjudication where someone's gone through some kind of hall of mirrors in an agency process and gotten a bad outcome.
Are you concerned that courts are not following Vermont Yankee well enough? I mean, that was one of the prongs of your decision in the radio relay case, that perhaps the Portland cement requirement, which strangely enough is a procedural requirement required by Judge Leventhal, that agencies give notice of important studies that are in their possession when they begin a rulemaking.
The short answer to your question is no, I'm not concerned about that. I think Portland Cement predated Vermont Yankee, and we had to follow it as a matter of circuit precedent. Right. I pointed out there was inconsistency there, but it was circuit precedent.
Okay. Does anybody have any questions or comments from the floor? I see a lot of people who... Yes.
Another issue on Vermont Yankee, which said agencies are not to add new procedures for agencies. What about the paralyzed veterans doctrine in Alaska Hunters? It says, the APA says interpretive rules do not require notice and comment. That doctrine says the first time you interpret a legislative rule, you don't need notice and comment, but you can never change it without notice and comment. Does anyone see a conflict there?
Well, that's a good question. I think that only applies, or some later cases have made it clear that it only applies to situations where the interpretive rule was of very long standing and also had been relied upon by third parties. But nevertheless, it does raise that question. Does anybody want to take on that Alaska professional hunters question? No?
Yeah.
It's not something I've thought about a lot about recently, but as I understand the reason for it was that interpretation is what sets the original rule in place. In the agency's mind, that's now what that rule means. And it's really referring back to that original rule. And so that if you change the interpretation in the future, it's not so much that you're changing the prior or subsequent interpretation. You're actually, in effect, amending the original rule that was done with notice and comment. And if you're going to do that, you have to have a further round of notice and comment. That's the rationale, I think, for the...
Right. I suppose there could be a Vermont Yankee type of argument against imposing this additional procedural requirement on the agency to go through notice and comment rulemaking for an interpretive rule that previously was issued without notice and comment through the interpretive rule exemption. But I think some later decisions, and there's been some critical commentary of that, and some later decisions have limited that doctrine in several ways. So the Supreme Court has not ruled on that at this point.
I think, can I just say one thing? I mean, that's an example that may actually stick out by its rarity of something that might be considered relatively new. I think that dates in the 1990s, roughly. But in general, this circuit is, my perception from reading the cases, is very aggressive about following its own precedent and not striking out in new directions on these things.
You know, it's interesting that the Vermont Yankee case itself, the decision by Chief Justice Rehnquist, referred to a rulemaking record in that decision. And a rulemaking record is not something that's in the APA for informal rulemaking. So even the Vermont Yankee decision itself assumed a requirement that was not in the APA.
Yeah, but that's the ACUS recommendation.
Well,
we defined the record for informal
after your study, right?
It still works.
Right. No, I'm not saying it was an improper thing. It was just kind of ironic that it appeared in the Vermont Yankee decision itself.
Yes, hello. My name's Michael Edwards. I work at the Credit Union National Association. My question is whether, in your opinions, the courts are more likely to give factual deference to financial regulators like the FDIC, particularly in light of the financial crisis that's hopefully now over. I ask this in part because of the recent decision by the U.S. District Court for D.C. Regarding the Advanta Bank case. I don't know if any of you heard that, but it was a rare instance where a court invalidated an FDIC enforcement action. Thank you.
I'm sure Judge Kavanaugh doesn't want to comment on that case.
I don't think the Southern District of New York feels, at least the Bank of America settlement, which was obviously financial matter, was taken under great close scrutiny. And I would expect.
He rejected the original settlement.
It was rejected.
Judge Rakoff.
By Judge Rakoff. And I just think the judges, maybe like everybody else, are thinking very hard about financial and consequences of not minding the store at the right time. And so it just would strike me, and Judge, you would know better, but it seems to me the judges will be alert to financial issues and regulation more, rather than giving them, more deference just because it's complicated. I mean, now this really is Bazelon and Leventhal again. I think they'll be alert, as everyone else is, and sensitive to the fact that some of the agencies weren't doing their job at the right moment.
I'm sure you know that in the Supreme Court's National Credit Union Administration case, the court overturned the NCUA's interpretation of its own statute under Chevron Step 1. So, in the back.
Enrique Armijo from Covington and Burling. I wonder if y'all had any thoughts on the proper remedy for a successful rule challenge. Here in the circuit, Judge Randolph seems to believe that vacating the rule is always appropriate. Judge Sentell seems to say that if a rule is so unreasonable that the agency can't explain it, vacating the rule is appropriate. So I wonder if y'all had any thoughts on that.
Anybody have any thoughts on that?
Go first. As you say, that's a long-standing debate in our circuit. We don't have a rule of automatic vacator, and that's been a debate that's gone on. And because it's not automatic, we debate certain factors as to whether to vacate or not in a particular case. And
in some cases, vacating the rule might be a hardship. I mean, it might provide a hardship, and if the agency can easily fix the problem, maybe the rule should be allowed to stay in place while it fixes the problem sometimes.
I will say one thing on this, which is when the rule is not vacated, when it's determined to be arbitrary and capricious because of a lack of sufficient explanation, it's not vacated, it's sent back for further explanation. There are cases I've seen where it takes years for the agency to do it, because sometimes the agency thinks it's won if the rule hasn't been vacated, regardless of what the rest of the opinion says. So that's something that I've observed.
Yeah,
Does anybody have any views on Chevron Step 0? We haven't talked about Chevron very much at this program, but with the Meade case and Christensen before it, raising the question or trying to answer the question of when the Chevron test and Chevron deference should be available to what types of agency interpretations of their statute. This issue now has become complicated, and Meade's been cited by hundreds and hundreds of cases. But it's very rare for a court to say or to indicate that we would have upheld this agency interpretation under Chevron, but we're not going to uphold it under Meade. So it makes me wonder whether all the ink that's being spilled in the law reporters on Meade and Chevron Step 0 is worth it. Worth the candle.
Go ahead, Howard.
Well, I think, I guess the official subject of this forum is rules. So if you're talking about rules that are issued after notice and comment, I think they're going to be more likely to get the Chevron deference. And as I mentioned earlier, it's really not a Meade issue per se, but what sometimes gets in the way of the Chevron deference, and it's a fairly restricted, at least in the environmental area, because these constitutional issues, Commerce Clause issue, or something that may come in from time to time.
Mm-hmm. I realize I'm straying off the rulemaking path here a little bit.
Well, I agree with you. It's not clear how often it makes a difference, but it does.
Does it make a difference in your mind when you're reviewing a rule and you realize this is one of those, not a rule, when you're reviewing an interpretation, and you realize this is one?
It makes a difference in how you approach the question, no doubt, but how many outcomes are different is something that is difficult to quantify, I'd say. But yes is the short answer. If the statute's ambiguous or the rule is ambiguous or the policy statement, then.
But isn't it a reasonableness test under either one? Question.
Hi, I'm Justin Pideaux. I work for the Department of Justice, and I'm not representing a department here, just myself. But in reference to that last question, I wonder about the Coralaska case from last term and whether or not that was a case in which the Supreme Court gave Chevron-style deference to an agency regulation, which basically just restated a statutory, the statutory language, and whether or not you expect to see agencies sort of using this device to get more deference by simply restating statutory terms in their regulations and then interpreting those regulations, and voila, suddenly they're sort of getting more leeway.
So you're raising a slightly different question. Rather than deference to the agency's interpretation of a statute, it's deference to the agency's interpretation of its own rule, and there's a separate line of cases, the Our Seminole Rock line of cases for that. However, it's pretty much the same. And you're, in at least a couple of cases, at least one that I can think of, what was the name of it? The Oregon Death with Dignity case, I think it was. Or not the Death with Dignity. Well, anyway, it was Justice Kennedy who came up with the anti-parroting doctrine, which said that it wasn't appropriate for an agency to simply parrot the statute with a rule saying the same thing and then claim deference to its informal interpretation of this regulation. So the Supreme Court at least is alert to pretty extreme versions of that at this point.
That makes sense.
Have you encountered that in the D.C. Circuit, Judge Kavanaugh? This question of an agency trying to get bootstrap deference by
I have not been on an anti-parroting case.
Okay.
I was Barrett Prettyman, Jr. I was a little confused by your discussion of the situation when the president has strong views for or against a particular proposed rule. Does he submit his views directly to the agency, and does he use a situation similar to that used by the Solicitor General in presenting the views of the United States to the Supreme Court? Those views, while said to be the views of the United States, as you know, and in many instances are in fact the views of the president. But once they are transmitted to the agency, if they are and if they should be, how much attention should the agency pay to the views of the president?
Michael, I think that's your bailiwick.
I think Judge Kavanaugh raised it. I will be happy to step in and answer the question. And first of all, just to take a step back historically, since the beginning of the Reagan administration, and even in various forms preceding that, each successive president has either written or endorsed a pre-existing executive order, which sets up a process for interagency review of significant, or in the Reagan era, all rulemakings that came out of the agencies. This is, I think, taps into a broader debate, which I will not wade into right now, of the sort of the unitary executive versus the non-unitary executive. But suffice to say that Presidents Reagan, Bush 1, Clinton, Bush 2, and Obama, who I don't think are peas in a pod, have all endorsed some form of centralized regulatory review and have tasked OMB and OIRA specifically with doing that. The executive order sets out sort of the family rules, which is that there will be interagency review. OIRA coordinates it. It's an attempt to get a lot of voices and perspectives involved in the formulation of regulatory policy. Very, very often, a rulemaking from one agency absolutely impacts the equities of other agencies. This happens all the time, particularly in the environmental area, public health areas. And you have the president and his or her advisors in the executive office of the president who may have a perspective on the regulatory action. It seems at least to me, a good thing that the President has some mechanism by which to kind of oversee what's going on in this sprawling administrative state and to ensure, one, that what his or her agencies are doing are issuing regulations that comport with statute. Second, that the regulations at least generally comport with his or her political agenda that they ran on, and that there's sufficient interagency coordination so that other parts of the federal government are not going to be adversely impacted. And then there's the sort of analytical component of the process which attempts to ensure that big, important rules that are going to have a big impact on society have a sufficient analytical underpinning and that there's been enough kind of a second look internally before they go forward. The hope is that because of that, they will be much more, I think, able to survive the inevitable challenges that come. So I don't know if that is a sufficient answer for you, but the President tends not to actually provide his direct input. That would be an exciting moment for all of us in the review process. But occasionally issues do rise to the Oval Office. But more generally, you have the various offices of the Executive Office of the President, all of whom are participating in this, and then all relevant agencies who might have some equity with an agency's rule also participate.
It's interesting, just to Mr. Prettyman's question about the SG's office. The leading article on presidential, it's called Presidential Administration, is written by the current Solicitor General, which advocates for the President's role in overseeing rulemaking, an active role. And in fact, the subject, this is Elena Kagan's article in the Harvard Law Review several years ago when she was working in the White House, but the subject of that rule was the tobacco rule by the FDA, and it was very clear, at least in that rule, you don't happen to see it a lot, but that the President had to step in. You're not going to tell the world we're going to regulate tobacco or tobacco for children, and the President is not part of that. So that evolution of that rule, going from the FDA to the Health and Human Services to the White House, was very interesting, and it shows how much now whether this would carry over to the SG's office, that is Presidential Administration, is an interesting question. There's a recent article by Maggie Lemos, my former colleague at Cardozo, who says that in the SG disagrees with the agencies about 27% of the time, takes different positions over looking at the briefs over a period of years. And so that 27% is potentially, the executive or the White House disagreeing with the agencies, I suppose.
Jeff, if I could, I want to add two additional points. One is, when legal issues arise in the course of the interagency review that occurs, it is absolutely the case that justice is consulted, that the lawyers, I work for a guy named Cass Sunstein. He knows a thing or two about the law. He's written a little bit about it. But we, and I am a lawyer too, we try, though, to not act in that capacity. We try to coordinate the review, and we try to rely on the agency's lawyers, the OMB counsel's office, the White House counsel's office, and the Justice Department and all of its expertise in resolving these issues. So that's the first point. The second point is it varies from administration to administration, and different presidents take, I think, different perspectives on the regulatory state. That's why we have elections. This president and the one I worked for before, the Clinton administration, take a view of regulatory review which I think is very much one of working with the issuing agency to kind of ventilate any questions or concerns or issues. And I think it is the desire, and almost always the case, that at the end of the review there's a consensus of opinion of what, if any, changes should be made as a result of the process. So we don't tell agencies what to do. We work with them to kind of ensure that what comes out at the end of the process, everybody agrees is better. At the end of the day, the agency is delegated the authority, the agency is the expert, and it is their rule, and I think that's an important point.
I think, again, putting aside the question of independent agencies, it would be somewhat surprising if, with a really big, important rule, the president were walled off from the decision, because the president ultimately is responsible for it. When it's issued, it's going to, the stories about it are going to say Clinton administration or Bush administration or whatever they're going to say about the, and so the president's not only supposed to, but is responsible ultimately for the execution of the laws by the regulatory agencies. One of the worst things you want to hear as a White House staffer is something I occasionally heard, which was, why didn't I know about this? And that's something any president will want to avoid, and any staffer for a president will want to avoid. So I don't think it should be viewed as in any way, as I said earlier, suspicious that the president would be involved in rules. In fact, I think it would be suspicious if the president didn't know about big rules that were going on in the president's name in the executive branch.
And Judge Wald's opinion in Sierra Club on this point is in all of the administrative law case books. So it's the leading word on that. Any other comments? I see other people in the audience who I would expect to be raising some questions.
I'm Steve Pollack, the president of the Society. Whether you give this a hard look or a soft look, this panel was outstanding. Thank you, Judge Wald, for conceiving it, identifying the panelist and the moderator. Thank you, Jeff Lubbers, for your penetrating questions. And to each of the panelists, Mike Fitzpatrick, Judge Kavanaugh, Howard Fox, Paul Verkuil, thanks for your real-world analysis of what the court's role should be in reviewing agency rules. And thank all of you for coming. That's really special.